an hour, so we're here till sort of 3 o'clock, and it's really essential HR for small charities, and we're delivering this webinar twice actually this week, so today and then again on Thursday, all part of Small Charities Week. And the reason we do that is Roots Human Resources. We are a specialist consultancy for human resources in the social sector. So we are a social enterprise ourselves. So we operate on a greater than profit basis, in the fact that as a social enterprise, we reinvest a portion of our trading surpluses to be able to provide pro bono or free HR services back into the sector to enable sort of learning and development for people managers within the sector, and also to hopefully improve people management within the social sector. So we're a social enterprise. We work with other social sector organisations. So we're working with a lot of charities. Around 70% of our clients base is charities. And we also work with other sort of not-for-profit type organisations as well. So we're really pleased as part of our sort of social impact to be able to deliver sessions like this. And what I'm going to do throughout the sort of the webinar today is just signpost you to other bits of free resources and information that you can get from us. I'll also signpost you to some other good support and information that's available to you as employers. But I'll certainly signpost you to more of the free support that we provide so that you can access some of that information in more detail. So that's a little bit about us. We're really pleased to be able to offer this session as part of Small Charity Week. And what we're going to run through with you today is kind of for small charities, and we work a lot with small charities. You know, there are things that you need to be aware of, particularly as you're starting to recruit, or if you've got a small team working for you of employees. So we're going to sort of just touch on an understanding of some of the main employment rights for employees within your organisation. And then we're going to go through sort of quite high level guidance, but also signposting you on to further support around how to sort of manage typical situations that will arise during the course of employment. So that'll be including things like managing performance, dealing with time off, flexible working, changing terms and conditions. So those are the topics that we're going to cover today. So there'll be me going through this presentation with you through these slides. You'll get a copy of the slides after the session. And then once we've gone through the slides, there's opportunity for Q&A. So we'll use the chat function to be able to sort of manage the Q&A. In fact, there's actually the Q&A button that you can press. So we'll use that rather than confusing things with the chat. So I'm going to start by just looking through the sort of the main employment rights for employees within your organisation. And you'll see here in the corner, I've just starred that we have, this is one of our free resources that we offer. We have a fact sheet, which is called Starting to Employ. And that covers off a load of the information that's available on this slide and goes into it in a little bit more detail. So when you get through the copy of the slides, there's a link here which will take you through to be able to request that fact sheet. But I'm going to cover it off in sort of a bit of high level now. Apologies if that slide looks a little bit blurry. It's not blurry on one of my screens, but it is on another. But we'll work our way through it. So this is kind of a bit of a framework around that sort of minimum compliance. So I'm going to start at the top where it says, if you can't read it properly, I'm not sure if it's blurred, contractual. The key thing around sort of contractual compliance that you have when it comes to employees within your workforce is that you must provide them with a written statement of terms and conditions of employment from day one of their employment with you. That's changed in recent years. You used to have a period of time to be able to issue contracts of employment. Now it has to be on day one. We do offer a fact sheet that's around what needs to be included in those terms and conditions as well, if you've got any queries around that. not necessarily contractual, but thinking about a new starter into your organisation, one of the things that you do need to do is make sure that you've done your right to work in the UK checks. There might be other pre-employment checks that you're looking to do, references. It may be that you do criminal records checks through DBS checks, but legally you are required to do a check that the individual you're employing has the right to work in the UK. The next sort of hexagon talks about pay and benefits. And the key thing here with your employees is that you must comply with a national minimum wage. And that includes the national living wage, because we have a number of different levels of national living wage and national minimum wage, dependent upon your employee's age, if they're an apprentice, etc. And be mindful that those rates increase on an annual basis, and it's typically in April of each year. You also need to be mindful of pension auto-enrolment, and this is in regard to workplace pensions. There may be some of your employees who you have to automatically enrol into a workplace pension. You may have some people within your workforce who you're not required to automatically enrol them, but they can request to join the pension scheme. So you need to have a workplace pension scheme in place and fulfill your duties in regard to auto-enrolling any eligible employees. And there's also some certification that you have to do with the pensions regulator. Now, your employees, when you engage them, will typically be entitled to some statutory benefits and/or payments if they meet certain eligibility criteria. Again, this will include things such as family leave pay, so things like maternity, adoption, paternity, etc. Statutory sick pay. They will have the right to have statutory notice periods within their contract of employment, and that means associated pay for that period of time. And also potentially after 2 years service, they would become eligible for sort of statutory redundancy pay. So there are statutory payments or benefits that individuals may be entitled to, again, subject to eligibility criteria. And another thing to be mindful of is that, again, those rates will tend to change and increase with effect from April each year. So things like statutory sick pay, statutory maternity pay, the level of a week's pay that you use in calculations for redundancy pay will change on an annual basis in April each year. So moving on, just to touch very briefly on working time and leave, because we're going to talk a little bit more about time off as we get into the sort of situations that we're dealing with on a regular basis. But you'd be required to comply with working time regulations in regard to the employees' working hours, things like rest breaks, and the biggie for that being annual leave. So employees have the right to 5.6 weeks annual leave per year, and that's pro rata for sort of part-time employees. There are some other statutory elements of leave or time off that employees could become eligible for. We've touched on one version of that, which is things like family leave, so maternity, adoption, paternity. Introduced in April this year was the right for carers to take up to a week, so up to 5 days unpaid carers leave within a 12-month period. There's right to the emergency time off, again unpaid, for dependents. Time off for public duties, which could be things like if you were a justice of the peace, time off for sort of jury service, and also an entitlement to some form of paid parental bereavement leave on the death of a child for an employee. We'll touch more on leave as we go through the session, and also pick up on the right to request flexible working. But from day one of employment, now I will say that we're not, as a HR consultancy, we're not sort of health and safety specialists, but obviously it's an area that sort of fits alongside HR, so we can sort of give you some high level guidance around it. But the key thing to be aware of is when you're employing staff is that you have a duty of reasonable care to your employees. So you have to make sure that you select proper and competent employees. So you need to think through your approach to recruitment and selection, that you provide them with adequate materials and resources to enable them to do their work safely. And you have a requirement to either display or issue your employees with either a health and safety poster, we may have seen those around, workplaces, or a health and safety leaflet. So if you have anybody who perhaps works remotely, then making sure that they've got access to or are given a copy of a health and safety leaflet. Again, we'll come on to this, but if you have 5 or more workers in your organisation, then you are obliged to have a health and safety policy in place. Again, from day one of employment, the next sort of hexagon is the right not to be discriminated against. So from day one of employment, your employees have the right not to be discriminated against. And that's in regard to the protected characteristics that are set out in the Equality Act, but which include things like age, race, sex, sexual orientation, pregnancy, maternity, so all of the protected characteristics within the Equality Act. So it's the right not to be discriminated against on the grounds of those protected characteristics. There are some types of discrimination that can potentially be justified. That's sort of a more in-depth, detailed look at equality and diversity. There are some webinars that are available on our website that will cover that. And I would say if you have any queries about that, it's best to seek sort of professional advice. What you also need to be mindful of is that any part-time workers that you have the right to be treated no less favourable than comparable full-time employees. So that's particularly when you think of things like perhaps their terms and conditions of employment, the benefits that they're eligible for, doing things like pro-ratering their annual leave, so they get the same sort of pro rata annual leave as a full-time employee would. And again, for fixed term employees, so this might be employees where you've engaged them on a fixed contract for a period of time, which might coincide with perhaps some funding or a contract that you've been awarded. Then for those employees, they have the right to be treated no less favourably overall than comparable employees on permanent contracts. So again, if you've got any concerns with regard to the contracts or benefits that are offered to either part-time employees, fixed-term employees, then again, I would say seek some professional HR guidance in that area. When it comes to data, and obviously here, because I'm talking about the employees, we're talking about workforce data, then you're required to adhere to the UK GDPR. So the General Data Protection Regulations, if I remember to say that correctly. So that's the UK GDPR. It became UK GDPR when it was sort of brought into UK law after Brexit. And we also have the Data Protection Act 2018. So it's about ensuring that you're following the requirements of GDPR when it comes to your workforce data. There are other employment rights that individuals have. As I say, most of those are set out in our fact sheet that's linked to here, that's called Starting to Employ. But other rights will include things like the right not to be unfairly dismissed, but that's specifically for employees at the moment who have more than 2 years service with the organisation. I say at the moment, as obviously we are awaiting a general election in the next week or so. And that duration, that length of service requirement is actually detailed in the election manifesto of one of the parties. So that may change in the future. But thinking about that framework, a question that we'll often get, particularly from smaller charities, will be, so what HR documentation do I need to have in place? And quite often we've also seen some organisations that I think are tempted to sort of copy and paste policies that they may have previously used at previous employers. So whilst that can be helpful in some situations, quite often what they're doing is bringing in policies that are applicable to a very large organisation into a very small one, and it can make things very over bureaucratic and difficult to administer. So we always come at thinking about documentation and policies through the lens of the size of the organisation, what the services are that you deliver, perhaps what the requirements are that your sort of funders have. So in terms of thinking about the documentation, we talked, and this is thinking about this as an absolute minimum, but we talked about the fact that you need to issue a statement of terms and conditions of employment from day one of the individual's employment with you. That information is typically contained within the contract of employment itself. Part of it may be covered off in an offer letter, but you want to make sure that you've got that sort of contract of employment that covers off everything that you're required to set out to that employee on day one of their employment with you. And again, as previously mentioned, your employees should have either access to or sight of a health and safety poster or a leaflet that sets out health and safety requirements. And because you're required to provide them with safe systems of work, then it's assumed that you would have a series of risk assessments that identify various risks within your organisation and how they're managed. When it comes to looking at policies, there is literally in law only one policy that you're required to actually have in place, and that's when it comes to health and safety. And if you have 5 or more workers within your organisation, then you're required to have a health and safety policy in place. For the rest of the policy document that you have in place, we will normally say to people, think about things like managing risk. What are the risks associated with the work that you're delivering? For example, if you're working with children or vulnerable adults, then it's highly likely that you're going to need to have a safeguarding policy to manage those risks. Think about recurring situations that you might have within your organisation. So you might think about sickness absence. We might want to have a sickness absence policy in place to deal with, how people notify us about absence, things like sick pay, how we manage absence. Do your commissioners or funders, if you have them, have any specific requirements on you? Sometimes contractually they will require you to have specific policies. So again, that could be something like equality and diversity. It could be safer recruitment. So there might be requirements that you have from your commissioners or your funders to have policies in place. Then there's also the wider sort of thought in terms of the type of organisation that you want to be, and perhaps thinking about attracting employees into your organisation. We kind of think about that as being an employer of choice. So an employer of choice may want to have policies in place that they think are not only going to be beneficial to their workforce, but also beneficial to the organisation, because you might be supporting your employees, but you also might be attracting candidates to your organisation. So that might be something like a well-being policy. It could be something around, career progression. I'm just plucking things out of the air at the moment, but it's thinking about that sort of wider landscape of being an employer of choice. So in terms of what we would normally suggest for smaller organisations, we would typically say, if you've got 5 or more workers, health and safety policy. If you're managing data, workforce data, you may well be managing other types of data within your organisation. Then you might want a data protection policy that might help you manage a risk around data. You might want an acceptable use of IT policy. Again, if you've got workers or employees who are using IT, communicating with service users, etc. So you might want an acceptable use of IT policy. You may want a policy around sort of absence or leave arrangements, because that might be one of the recurring situations where you really want managers to be consistent in how they're dealing with this in your organisation. And then things like equality and diversity, which obviously go towards maybe not only supporting what you need for your funders and commissioners, but thinking about what you want to say to the wider employment market about your organisation. So those are the policies we would normally recommend. And we normally say that, you know, for policies to be effective, they need to be written and scalable to the size of organisation that you are, implemented, so people need to be aware of them, managers need to know how to implement the policy and deal with employees or manage employees within the scope of that policy. And then that can really give you a framework of sort of good people management practice, consistency in how employees are managed. And so management can seem fair to your workforce. And again, that's something that's always really important in terms of you know, retention and your workforce. So if they're well written, consistent, then it can really help, and it can actually help with some of the situations that we're going to move into and talk about now. The first one being around managing performance. So when we're managing performance, what we're talking about is essentially whereby a manager, on behalf of the organisation, really defines to an employee what good performance and behaviours look like. That's typically through setting of standards and objectives, provides any support that the individual might need, monitors their performance, and sort of provides feedback to them. And when done well, it's a really useful tool because it can really help improve performance at an individual level, a team level, an organisational level. And it can help improve employee engagement. It can help sort of reduce things like absenteeism, and it can help obviously reduce management time and costs potentially spent on managing underperformance. So essentially, in terms of managing performance, what we want to be able to do is to answer 3 employee questions. And those are the questions that are on screen at the moment. So what's expected of me? So this is where we set out the standards. That can be through things like contract of employment, through policies, the expectations that we've got of the individual. So within their role, that can be set out within their job description, can be set out in any objectives that you set with the individual. So the individual has a clear understanding of, within this organisation, in this role, that I know what's expected of me, and ideally that they can see how that fits with the broader organisation and what the organisation's trying to achieve. Once they know what it's expected of them, it's answering the question for them of, so how am I doing? And this is the part where it's around monitoring performance and giving feedback on that performance. I always think monitoring performance sounds really scary and like you're sort of doing something that you shouldn't be doing. But monitoring performance is typically things that happen on a regular day-to-day occurrence. You might observe somebody in a conversation with a service user. You might receive an email from them. They might have written a report to you. You know, it's that natural everyday observation that can help in that, you know, sort of be that monitoring of their performance. And then feeding back to the individual on a regular basis as to how they're doing against those objectives or standards and expectations that have been set. So you might have monthly one-to-ones or supervisions with staff. You may even have an annual appraisal. And then it's answering the question, what does that mean for me? For some people, there might be a reward element. So it might be an impact on their pay in terms of their performance. For others, it may be around simply being able to see the impact that they're having on service users. For others, it may be that it's talking about sort of career progression and prospects within the organisation. So managing performance is essentially about answering those 3 questions for individuals. And we tend to do that at various points throughout what we call the employee life cycle, which is the whole duration that the employee is in your employment. You start setting out those expectations within things like your job description. So that can be expectations in terms of the role itself. You might have information in there on the the values of the organisation. You can set out expectations in other documents as well, so policies, handbooks. You might start the assessment of that individual's performance through your recruitment and selection activities. So that could be looking at, the interview questions you're asking, any tests that you might put candidates through. And then in induction and probation and moving forward into sort of one-to-one supervisions and appraisals is where you've started that cycle of then having set the expectations with the individual, being able to talk to them then about their performance. So observing what you've observed, the feedback that you can give them on the performance that you've observed in your role as their manager, and whether that is currently meeting the expectations of the organisation or not. So managing performance is something that kind of happens a lot during that initial sort of thought of developing job description right the way through to inducting and managing the probation of a new starter. And then once you're sort of through the probation period, it kind of becomes an ongoing process whereby that discussion around performance, the feedback to individuals on their performance happens in those one-to-ones, and then potentially, if you have an annual appraisal process, through those sort of annual appraisals too. So again, it kind of becomes an ongoing process that as people managers, you're typically following with those individuals who are your direct reports. But managing performance can sometimes then mean you're managing underperformance. And I think it's really important when you're potentially managing underperformance to be clear, what does that look like in the first instance? So making sure that you've set those expectations correctly. So you know that somebody who's performing at the expected level is the good performance that you're looking for. If somebody isn't meeting that expected level, then you've got an issue of underperformance. And the key thing is through those one-to-ones or supervisions, so the more immediate conversations that you're having with people, is to, through that feedback, identify that there is an area where the expectations are not being met. And what that can do is that can help you have a conversation with the individual to understand the root cause of why that expectation is not being met. Because typically this is where we'll know whether this is potentially a capability issue or potentially a disciplinary issue. Now on the slide, I've sort of captured things under two headings of won't and can't. And won't is where we might be looking at a potential disciplinary issue. Almost created a new word there. And can't is where we're looking at a sort of a potential capability or underperformance issue. So we think about it like this. Won't is where somebody is willfully making a choice not to do something. So they could do it, but they've essentially chosen not to do it. So it can be perhaps an attitude or an apathy issue. Can't is where actually what we're talking about there is sort of skill. And it may be that they don't possess the skill or knowledge to be able to achieve that expectation that you've got. And you'll be sort of following two separate processes depending on what you believe the situation to be once you've had that initial conversation and, you know, sort of tried to nip in the bud and feed back to the individual the issues or concerns you have with underperformance. If it's misconduct, so if somebody's choosing not to do it, then you'll follow your disciplinary procedure. If it's an issue where somebody can't, so it's more to do with skill, knowledge or ill health, then we're looking at capability. Now, if it comes to light that actually there's an ill health or an injury reason why the individual can't perform at that particular level that's required, then it's likely at that point that you're going to need to get, again, some professional HR advice, because you're likely to need some medical guidance, so either from the individual's GP or potentially an occupational health provider, to talk to you about the employee's current state of health or injury, the impact that's going to have on their job, if they're off work, how long they may be off work, and guidance in terms of any sort of adjustments or steps that you might take to be able to get them back into work, and how that might help and how long that might take. So ill health capability, if you have somebody who either due to ill health or injury becomes incapable of working or delivering at the expected level, that's something that I would recommend that if you're dealing with that, it's something you take professional HR advice on. If you establish through that conversation that this is something that the individual is simply lacking the skills or the knowledge to be able to deliver, so it's not related to their health or an injury, then that's sort of more the underperformance that you can hopefully, now that you've identified that where the underperformance is, work with the individual over hopefully a short period of time to enable them to meet those expectations. So that can start off as a fairly informal process, and you might use something such as a performance improvement plan, sometimes termed as a sort of a PIP, whereby within that discussion, you'll identify where the gap in skills or knowledge is. You'll be able to look at what support the organisation can provide the individual to enable them to meet that development need that they have. And then you'll be able to set some expectations with the individual in terms of perhaps objectives or timeframes for when the improvement in performance needs to be achieved by. So that can quite often be delivered through a sort of a performance improvement plan that you can monitor frequently, perhaps through your regular schedule of one-to-one meetings. And if there's progress and the individual achieves a sort of sustained improvement in performance, brilliant. That's what we're looking for. That informal process that you've followed has created the impact that you wanted, and the individual's now achieving the level of performance. If there's no progress or inadequate progress, then it could be that what you're needing to do then is moving to a more formal process. Now, again, if you're a smaller organisation, you might not have a sort of capability policy in place that sets out the process that you should follow there. So I would say in terms of that, if you are looking to move to a formal capability process, having informally tried to work with the individual to improve their skills or knowledge, I would say at that point that you're looking to take the process potentially formally, to make sure that you're following any policy if you do have one in place, and or that you're taking sort of professional HR advice at that particular point. But more often than not, if an issue in terms of skills or knowledge is identified early on through that regular feedback conversation that you're having with individuals, it enables you and the individual to work to fill that development gap that they've got and to improve performance. If those conversations and those early interventions don't happen, what we often see is this then snowballs and the performance starts to deteriorate even more, and it becomes a bigger issue and has a bigger impact on the team and the manager involved. So nipping things in the bud when it comes to underperformance is really, really key. I'm going to move on and just start to touch on sort of time off. I've got one slide here which looks fairly scary. There's a lot of information on the slide, but that's done so for the purpose of being able to sort of signpost you to some additional information. So we touched on some of the rights that employees have in terms of time off at the very start of the session. And that includes things like annual leave, sickness absence, and sort of family leave, and other types of statutory leave. So what I've done here on this slide is basically through the links, so those areas that are highlighted in blue, being able to signpost you to further guidance on those particular areas if that's something that you're not familiar with or you would like further information on those areas. Helpful links there include things like a link to carers leave. So that was the new leave that was introduced, new entitlement to leave that was introduced in April of this year. So if you're not familiar with that at the moment, then that's the links to the information. Again, if you're not familiar in terms of things like entitlements to maternity, adoption, paternity, it's signposting you to the information there. What I would say is that shared parental leave that's on there is one of the most complex pieces of legislation I've ever come across. So I have signposted you to more information there. But again, if you have any of your employees coming to you asking for information in regard to shared parental leave, we do have a fact sheet available. You can request it through our website on shared parental leave. Key things to be aware of, just I'm going to touch a little bit more on sickness absence, but just a couple of key things to be aware of around annual leave, which is, again, we've already discussed 5.6 weeks annual leave as a UK statutory minimum, and that's pro rata for part-time employees. Some of your organisations may have what's referred to as part-year employees, might be known within your organisation as sort of term time employees. If you do have part-year employees or workers who work irregular hours for you, then they are entitled up to a maximum of 5.6 weeks annual leave as a minimum. But it can be calculated in a slightly different way. And there was, again, in April of this, I think it was April, in April of this year, there was a slight change to the legislation because some employment tribunal cases had very much confused the approach that you could take in terms of holiday for part-year or irregular hours workers. That's now been clarified and is easier in terms of employment law now. But if you do have any sort of term time, part-year, irregular workers in your organisation, then again, I would say that there is a webinar that is available on our website, which was delivered, I think it was delivered in January of this year, around the employment law changes that were coming into play in April. You can watch that as that has more information on it. Alternatively, I would say seek some professional support on that. But the purpose of this is particularly this slide is to signpost you to some of the additional information on these types of leave. But what I want to talk about in a little bit more detail is just around managing sickness absence and also just touch on flexible working as well. So when it comes to sort of managing sickness absence, I mean, individuals, if they are off sick, they have a statutory entitlement to statutory sick pay, SSP, if they meet the eligibility requirements that are in place. Your organisation may offer, it may not, but it may offer an enhanced level of sick pay, so something that's over and above the rate of statutory sick pay. If it does, then that's normally set out in either the contract of employment or the policy. But generally, through either a policy or a contract of employment, your employees will have a process whereby they have to notify you if they're absent or going to be absent from work. In terms of sort of absences, we tend to see still that the vast majority of minor illnesses that might cause short-term absence from work includes things like colds, stomach upsets, and migraines. The most common cause of longer term absence, which we would typically think of longer term as anything as sort of 4 weeks or above, tends to be more acute medical conditions and stress, mental ill health, and also things like musculoskeletal injuries and back pain. So we tend to see with the longer term illnesses that there's been an increasing number of sort of mental health issues and stress coming into that sort of the common cause of longer term ill health. So obviously most organisations are very open to sort of genuine cases of illness. However, you know, when it becomes excessive or unauthorised, the absence can have an impact on the organisation. And so it may need to be managed by managers within the organisation. In terms of managing that absence, the first thing we'd say is that, similar to performance, managers should monitor absence on an ongoing basis. So really you should understand for your direct reports what the sort of levels of absenteeism are within the organisation, within your direct reports. Now, if you do have a policy in place that covers sickness absence, as a manager, it's really important you become familiar with that policy. And one of the things to understand is whether the policy has any trigger points within it. Some policies have trigger points that really set out what are unacceptable levels of absence to the organisation. So that might be something like, I don't know, 3 separate instances of absence in a 12-month period. It could be absences of 10 days or longer. So, there are normally some kind of trigger points. If there aren't any trigger points or there's no policy, then it's really for the manager to think in terms of what level of absence is sort of acceptable to the organisation, or what level of absence is really starting to have an impact on, you as the manager, the team, the organisation, the service users. So kind of understanding what an acceptable or a reasonable level of absence is, and then making sure that if anybody hits those trigger points or starts to approach those sort of more unacceptable levels, that there is a sort of conversation that takes place between you and the employee. And typically that conversation, very similar to when we talked about managing performance, is really about trying to identify the root cause. So is there anything that's regularly causing the absence or the ill health for the individual? So is there an underlying health condition? And it may be that you want to look at, as a next step, taking something like medical guidance. So again, occupational health input, or perhaps a report from the individual's GP if there's a concern that there might be some underlying medical condition. And then that guidance can help to identify what might be adjustments that could be reasonably made to help the individual maintain a satisfactory level of attendance going forward. And then you can use, again, very similar to the performance improvement plan, a sort of attendance improvement plan, which is setting out the objectives, if you like, for the individual in terms of what's an acceptable level of absenteeism to have over the next period of time. And that approach, that improvement plan, is something that is then regularly monitored and discussed, perhaps at, your sort of one-to-one meetings. So it's really important, that kind of management of sickness absence is about thinking, do we have a policy? Does it contain any trigger points? If it doesn't contain trigger points, what's an unreasonable level of absence within a particular organisation or team? And then monitoring and managing absence in accordance with those levels. If the levels reach an unacceptable level or one of the trigger points, the key thing is having that early conversation with the individual, trying to identify root cause, seeking medical guidance if that's something that would be helpful, and then looking to identify any adjustments that might be needed to help them perform or attend at a higher level, and then putting those in place. If attendance improvement plans are put in place and they don't appear to have the required improvement in absence, if the significant perhaps medical condition identified by occupational health, then it may be that, again, there's a situation that you need to take professional HR advice on to look at whether the individual is in fact capable of remaining within that job, or if there are other options or alternatives that you need to consider, up to and including a potential dismissal. Again, that's quite a complex process, and there are significant risks there to organisations, particularly when we think about individuals having the right not to be discriminated against. So I would say that if an informal attendance improvement plan hasn't worked, or if there is a sort of a long-term absence, so an absence of 4 weeks or more, if you're sort of getting an occupational health assessment involved, you might want to take some further HR advice at that point to support you in terms of making the appropriate next steps and decisions. What I'm also going to highlight to you on this slide is that we have a webinar that's available on our website all around managing sickness absence. So if that is an issue for you at present, then I would recommend watching the sort of full webinar on that, delivered in the last couple of months. So it's very timely to get some more guidance on managing sickness absence. In regards to flexible working, so employees have a statutory right to request flexible working. It's not a statutory right to work flexibly, but it's a statutory right to request flexible working. That is now a day one right of employment. It used to be that you had to have 6 months length of service before you could request flexible working. It's now something as from April this year where an individual can request from day one of employment with you, and they can make up to 2 applications for flexible working within a 12-month period. If you can't agree to a request for flexible working, and there are 8 statutory reasons why you can refuse a request for flexible working, you must meet with the employee before you reject their request. The individual has the right to appeal against the decision that you take if they're not happy with it. And you have a 2-month timescale for handling the request, and that 2-month clock, if you like, starts ticking the day you receive the flexible working request, and it should end at the point that the appeal process has ended. So you've got 2 months from receiving the request to completion of an appeal process. Again, we have a fact sheet that's available that you can request from our website that takes you through the steps in terms of dealing with employee flexible working requests. But those are just the key changes that happened to flexible working legislation in April of this year. So then just touching on changing terms and conditions of employment. If you're looking to change terms and conditions, or potentially to vary the job description that an employee is employed to deliver, then the first thing that you want to do is to check the contract to see if there is a flexibility clause within the contract. Sometimes there may be a clause that, provided the job remains substantially the same, that you can make some small variations to either the job descriptions or the contract itself. So check the contract, because that could mean that you could make the change without necessarily having to vary the contract. So there might be some changes where you're simply needing to inform the employee of the changes, but that depends on the change that you're looking to make. In terms of if you're looking to vary larger sort of clauses, or if you don't have that flexibility clause within the contract of employment, and changes that you might want to make to a contract could include changes to job duties, location of work, hours of work. If you've got things like new shifts, or changes in service provision if you've re-tendered for a contract. But if you do want to make a contractual change and you don't have the flexibility clause, or it is a larger change, so it has more impact on the employees, then you will need to consult with affected employees to seek their agreement, to basically gain their agreement to the change. So where you've got potentially more than 20 employees affected, you would need to consult collectively. As smaller organisations, we'd typically expect you wouldn't be hitting that level, so your consultation with the individuals would be on an individual basis. The key thing would be to make sure that you've got a clear business case. So what's the rationale? What's the reason that you need to make the change? The consultation, for it to be meaningful, is then around ensuring that the individuals understand what the business case is for the change, that they're given the opportunity to understand what the changes are that you're proposing to make, and that they have the opportunity to put forward any alternate proposals or changes that you may or may not have considered. And what you'll want to do is to, as I say, consult with the affected employees to seek their agreement. If they agree to the change, then you can simply write to confirm the change in writing, and that's the end of the process. The new term can come into force. If you get to the end of the consultation process, it's clear that the business case hasn't changed, that the organisation needs to implement the change, but the individual is failing to agree to that change, then it might be that you come into the situation where what's become sort of colloquially known as fire and rehire begins, which is where you dismiss the individual from their existing contract and automatically look to re-engage them immediately on the new terms and conditions. Obviously, that's not ideal. The ideal approach is that through the consultation process, you're able to gain agreement, but ultimately, then it may be if you don't get agreement and you need to progress with the change, that you might be looking at the sort of fire and rehire approach. Again, I know that is something that has been in the news with, I think it's been used abhorrently by some larger employers, and it's brought it to the sort of forefront. And again, I think it's contained in the manifesto of at least one party for this current general election. So it may be something that we get changes on in due time. But there is some further ACAS guidance that I've signposted you to there. But if you're changing terms and conditions, it's really about, do you have that flexibility clause? And then if not, or if it's a significant change, then it's understanding what your business case is and consulting with those individuals about that. So what I hope I've done through this presentation is given you some sort of high level guidance, and when you get a copy of these slides, you can then use them to get the signposting to further information or support if there's a particular area that's of interest to your organisation at the moment. So I'm just going to open it up to questions at the moment, just to see if we've got any questions in the Q&A or the chat at the moment.
Hello, thank you, Alison. Can you hear me okay?
I can, yes.
Yeah. So we've got a few questions in the Q&A. Let me just load them up for you.
Yeah. Oh, I can see I've got a couple coming in here. I'll pick up that first one from Angela, which is, you talk about having workers. Does this include volunteers too? No, it doesn't. No, volunteers are completely separate to workers. So no, it doesn't.
Thank you. So the next one, our contract says that we're only entitled to SSP, no enhancement. However, trustees have given employees some sick pay. Do I need to rewrite and reissue the contracts, or can the change be written into a new policy to take effect?
Interesting question. Really depends on what you want to do. It depends on whether you want the sick pay to be contractual, the enhanced sick pay to be contractual or not. If it's contractual, then I would say write it into the contracts. If it's not contractual, potentially if it's going to be discretionary in particular, then you could develop a non-contractual policy and have it written within the policy.
Thank you. So we've got another one here. Someone's fairly new in post. An employee put forward a flexible working request to the former CEO, who responded by saying she'd give them an answer within 3 months. The employee says the request was agreed, but there's no paperwork to support it. Can I say that the employee needs to resubmit the request?
That's a difficult one, and it may be one that Lucy is best taken offline, and we can provide some guidance for that. We offer, one of the things that I will say, is part of our pro bono work, we offer organisations up to an hour of free HR consultancy if they're a social sector employer. So that's one, Lucy, where I'd say, rather than answering in this sort of public forum, if you want to, you can contact Charlotte. I've put contact details are next on screen. Next slide, if I can move that along. And you can contact us via any of those. So via the website, via the telephone, or via that email address. And we can talk to you further about that. I would say that's probably best.
Thank you. Next one then. So what if long-term sick individual doesn't communicate with the employer?
I think that's a difficult one. Sometimes it may come down to, I mean, essentially for business planning and for the business to continue, you need to be able to communicate with your employee to have an understanding of the likely duration of their absence, how you can work with them to get them back into work. But depending upon the nature of their illness, it may be that you have to make some reasonable adjustments for them. And an adjustment could be in terms of how you communicate with them or who you communicate to. So my first suggestion would be that it's about trying to contact the individual and saying that you need the reasons why you need to have communication with them, and potentially ask them in that if there is a preferred method or if there is an alternate way that they can think for you to be able to communicate with them whilst they're off sick. What I would say is that you say that that communication is going to be for anything that's business critical or in relation to their sort of sickness absence. So you wouldn't necessarily be wanting to bombard them with every piece of organizational communication. But that would be the first steps that I would suggest. If there's no response to that, or there's a continuing lack of communication, then that's the point at which I'd say probably take some further advice. And again, similar to Lucy, that could be through our 1 hour free service. Completely lost the word free from my head then.
Thank you. Just a few more then. So a flexible
Yeah.
working one, if you're declining a flexible working request, do you have to meet with a person in person or can it be virtually?
I think it can be any way. I don't think, off the top of my head, I don't think, and there is some ACAS guidance around flexible working, but I don't think it specifies. I think if you're doing it remotely, so via a Teams meeting, that's absolutely fine. And, there might be occasions where actually you can't meet them, and it might be that it's a reasonable adjustment that rather than having the meeting, you agree to do it via email. That can be a reasonable adjustment. But I would say try and meet with them. Teams would be absolutely fine, or Zoom, whatever way you do. Telephone would be fine if you can't do that. And then potentially, if you're struggling, if the individual can't meet with you through any of those formats, it might be that you can agree an alternate approach with them.
Thank you. Then we've just got one about bank holidays. So what if front of house have to work bank holidays? Do we add a date onto their entitlement, or does it come under the 5.6 weeks allowance?
Depends really what's in your policies as well, Elizabeth. Statutory, the 5.6 weeks allowance technically includes the entitlement to bank holidays, but your policy, if you offer anything over and above that, then your policy may say. But if their entitlement is 5.6 weeks and that includes bank holidays, and then they are required to work on a bank holiday, what normally happens is that day is in effect just still there available for holiday. So 5.6 weeks is 28 days. So if that includes 8 days of bank holiday, if I work a bank holiday, my holiday entitlement wouldn't suddenly go down to 27 days. It would remain at 28 because I've still got that entitlement. Does that make sense? Sorry if I'm confused with that, but yeah.
And then we just got one about sabbaticals. So they currently don't have a sabbatical policy. However, an employee has requested a sabbatical. This will be their second one in 2 years. Is their best practice when looking at this?
There's no legal requirement for you as an employer to offer or to say yes to a sabbatical. And as you don't have a policy, there's no organisational requirement for that. So I think the key thing is it's an organisational decision on whether you can allow the sabbatical, whether you've got sufficient cost to allow the sabbatical. If you do allow the sabbatical, then there's just some things that you need to be mindful of in terms of what parts of the employment contract may or may not continue during that sabbatical period. Again, that's probably, if you get to the point about, accepting and agreeing to a sabbatical, again, that's the point whereby I'd probably say take some professional HR advice to ensure that you're making the right decisions in terms of what happens regarding the terms and conditions of employment during that sabbatical.
Okay, we've got one in the chat here. So we use addendum to contract if the working hours or title have changed. Is that sufficient?
Let me just have a look at that. We use addendum to the contract to the working hours or title have changed. Is that sufficient? Right. So I'm assuming that is saying that we might just, if we vary the hours or the title, that we might just write to the individual to confirm that rather than issuing a new full contract, in which case, yes, that's absolutely fine. The change just has to be confirmed in writing. So a simple letter confirming that is fine. Sometimes if you do a large scale change to terms and conditions, you might end up saying it's easier to issue a full new contract. But if it's something like hours of work, a letter confirming that variation is fine. I know we've just had a question come through about annual leave again. I'm conscious of time, we are over slightly, but I will just answer that last question. So it's about bank holidays, and if somebody doesn't work on a Monday, but bank holidays are usually on a Monday, am I required to add these to their annual leave allowance? Again, this comes down to what holidays you offer. But what I would say is that if you have we got a webinar on that? Have we got documentation on that? Essentially, in that situation for part-time employees, what you would do is say that they have 28 days annual leave, if it's 28 days as their entitlement, say. So they might be part-time, let's say they work half a week, so we've prorated their entitlement and it's 14 days, they work half a week, so half of 28 is 14. Put that all in a pot and say that any holiday that they take, including bank holidays, is taken out of that 14 days. So if a Monday is not a contractual day of work for them, they don't need to book a holiday out of that pot for a bank holiday. So that's probably the simplest way I can explain it. Have a look on our website to see if we've got any more advice around annual leave. We might have, I can't remember off the top of my head. If not, I would say, again, you can use our free 1 hour of consultancy to if you've got any further questions on that.
Thank you. And we've had a couple of questions through from Carbon, but I think if we can come back to you by email once the webinar's finished. Does that sound good?
Brilliant.
Yeah.
Okay.
Thank you.
Well, thanks ever such a lot, everybody, for your time. I hope that's been helpful. As I say, we will send through a copy of the slides, and so you'll be able to sort of use all of the linking that I've put in there for signposting to additional resources as well. But thank you, everybody, for your time today.
Thank you.
Thanks, Charlotte.
Cheers.
Bye. Bye, everybody.